Okay, this is my ramble about jury equity, and I hope you enjoy it. I refer to 2024 when I should be referring to 2025. Anyway, enjoy. Well, it's February 2024. I'm sitting by the pool in St Lucia, waiting till Tuesday, hopefully to get a weather window to sail up to Martinique and then make my way slowly, repairs permitting, to cross the Atlantic for the fourth time and the third time in 3 years. But I'm a lawyer, and I've decided that I've been watching the news, and I've decided to encourage probably some students to look at jury equity, and perhaps even the powers that be to look at jury equity. Let's start with the Magna Carta. That's where jury trials started, and that's where you're judged by your peers. And jury equity is where you've got the right to acquit, or the jury has a right to acquit according to its conscience. And I speculate that could be many things. It could be the prosecution would start to be unfair, the penalty could be too great, it's not in the public interest. There could be numerous reasons, and they don't have to say what the reason is, which is important. And it can be notwithstanding, despite the judge's direction. So let's start with the beginning. Now, I discovered it started in 1670 with a case called the Bushell case, Bushell case. And this established the right to a jury to apply facts and apply the law according to its conscience, regardless of any judicial reprisal. And in this case, the Recorder of London, as we all know, a very senior judge even now, tried to compel the jury to convict two preachers for having unlawful assembly. And if you look at the Old Bailey, there's a plaque which establishes, and here's a quote, "the right of juries to give their verdict according to their convictions," close quote. Not that, my respectfully means in democracy according to their conscience. Now, I want to go a little bit further back in that. There's a couple of cases recently. To give an example, one was the case of Clive Ponting, who was charged under the Official Secrets Act for revealing information which would lead one to believe the Parliament had been misled about the Argentinian ship, being the Belgrano, being sunk. The jury acquitted him, notwithstanding the directions in relation to the breach of the Official Secrets Act. Furthermore, then there was the case of George Blake, who was a spy who died, I think, not so long ago in Russia, was awarded all sorts of things by the Russian state, but he escaped with the help of two chaps, Pat Pottle and Michael Randall, who they were acquitted, notwithstanding that their defences were ruled out. And I think, if I remember right, their motive was that they thought the sentence of 42 years was excessive. Now, whether that's true or not, I can't say, but certainly I've come across that as an explanation. And then more recently, there's the 6 of the 7 Shell Extinction Rebellion jury acquits in the face of the judge's direction at the Shell headquarters in London. There is another case pending, but I won't describe that because that's actually a retrial of a case which is going to be heard, so I'm going to stay away from that case. All right, so then we come to the case of Warner. Now, Warner is the most recent case, and I think I'm going to give you more detail of that, which is here. This is the case of Her Majesty's Solicitor General versus Trudy Warner for the lawyers amongst us, 2024 EWHC 918 King's Bench case. It was a contempt of court charge. Basically, there was a trial on the 27th of April 23 for defendants who were affiliated allegedly to the Insulate Britain group, and this case belonged in the London Crown Court. Those defendants were charged with public nuisance offences rising at the process. The jury had not been impanelled. No part heard cases were listed for that day in court. It was the first day of the trial. At 8:30 in the morning, Mrs. Warmer, a retired social worker, arrives outside the judge's entrance with her friend, and they had a placard which simply said the words, "Jurors, you have an absolute right to acquit a defendant according to your conscience." And that was to be called the placard in the case. Now, Mr. Justice Saini heard the case brought by the Attorney General. I must admit, I have a lot of respect for Mr. Justice Saini, and I think he got this right, although I do have some reservations in relation to how it should be dealt with in the future. Now, it's Honour Judge Reed who presided the original trial, and he said this: the only person that can tell the jury to do something about the way they approach the case is the judge in the case, and that's him. He said that the people that were showing the sign up, that they were wrong about what the law is, and the law is exactly what I told you yesterday. You try the evidence which you hear in the room and no more. You take the law from him. Anyway, that's all. That was what the trial judge said to the jury. So, what was the general consensus? Well, the general consensus, there is something called jury equity. And then His Honour Judge Saini said, what did the sign do? It simply communicated directly with the jurors to summarise the principle of jury equity. It didn't suggest that they should exercise their right to acquit according to their conscience, just that it was a power they have. Indeed, such a power seemed to be accepted on behalf of the Attorney Solicitor General. Now, he then makes the point, Mr. Justice Saini, that the Crown Court Bench Book does not have any judicial direction dealing with this, and that needs to be looked at. I'm not going to comment about substantive legislation. We all know what it is, but there is, I think, with respect, an increasing process by which the legislature, Parliament, want to control behaviour and speech which they find not politically expedient, or they have other reasons for legislating against certain thoughts and expressions of thought and behaviour and actions. Now, and I do remember we've always had plenty of law in relation to abuse of process, to public disorder, and so on. So this is all new stuff. This definitions of what certain words mean and what they don't mean. And it starts with the police officer in the street being required to make an assessment of what words mean or don't mean. And we've even got blank placards that are being held because people are frightened about what they should say on a placard. I think that there is now a need for the question of jury equity to be looked at. Now, I think the decision in the court was that a jury should not be told about it. Now, let me just go back to where I found that. Now, it says now, in that case in Warner, it said that it was agreed by all parties that participants in trial cannot be lawfully invited in trial to apply the principle of jury equity or even informed of it, and that's to revolve the tension between the jury equity and the oath that jurors swear. Well, that's daft, is it not? I mean, if you've got the power, the jury got the power, how does it make sense not to tell them about that? I think the words that are used should be carefully crafted, and some thought is required on that. But it's a nonsense to suggest that they shouldn't be told about it. So basically, it would be just pure luck whether the jury decide, well, depending on the defence point of view, a prosecutor may take a different view, whether they decide that they're going to acquit notwithstanding the position. So, if you also look at the Warner case, that meant that Miss Warner was allowed to stand outside with a placard, which objectively just says what their powers are. So have we not reached a stage now where we can have a bench book direction where objectively, in the appropriate cases, following discussion between all counsel, whether or not they can simply just be a placard type statement that the jury have that power? I think with the way the world is going and the way the internet's working, and some of the prosecutions that have been brought and the way the public react to some of the cases, that I think the public should take should be told of their ultimate sanction against the prosecutions in appropriate cases. And I think I don't know, I haven't read, I'm not sure what the decision was, why all the lawyers decided that the jury should not be told about their power in future cases. I think I'd be, if I was sitting, of course I'm not a High Court judge and I never was, but I think I'd entertain an application in an appropriate case from defence counsel, simply to say those words which are on the side of the Old Bailey anyway, and then let's see what the Court of Appeal makes out of it. Also, it's part of how our system works, the parliamentary system works. So anyway, there's my thoughts. It's brief, by the pool. It looks like it's going to start raining again. But anyway, jury equity then, and there are a number of other cases, but you'll notice that I've not commented on individual statutes or individual interpretations about words used to create offences. I think there's been plenty of other commentators doing a far better job of that than me. But I do think we are reaching the stage where the right that the jury has, it's not a question they don't have it, they do have it. The question is, how do we tell them about it? And I think we must tell them about it, because there's a plaque on the side of the Old Bailey telling them about it. So let's get on with it and do something right, which in my view is one of the advantages of having a jury. Heaven forbid that judges decided all cases of guilt and innocence. No, I think in a democracy, juries with all their potential flaws, it's still the right thing for a jury to make the ultimate decision, and to be judged by one's peers. And even if in a conviction, one may not agree with it, but at least it's the public, the jury or peer group that are making that decision, and not somebody in a rarefied atmosphere, and certainly not politicians. And I suppose while I'm on this matter, I think politicians should steer well clear of criticising the judiciary. There are some proper appeal procedures. They've got the ultimate, they can change the law to whatever they want, Parliament. So to keep coming go at judges for just doing their job seems to me completely wrong. And it never used to be like this. It's just a new fad. If they don't like the law as being applied by a judge, well, go to Parliament, change it, have the argument, debates, and change it. That's the right way to do it, and not criticise the judiciary trying to do their best. Anyway, that's my moan, and I'm retired, so I'm entitled to moan. I'm 35, and that gives me an extra entitlement to moan. But anyway, there we are. Have a nice day, you all.